Before the court is plaintiff State of Washington and State of Minnesota's emergency motion for a temporary restraining order. For the audience out there, the lawyers refer to those as TROs, and that's not initials that we like to see. The court has reviewed the motion, the complaint, the amended complaint, the submissions of the parties, the submissions of the amici, the relevant portions of the record, and most importantly, the applicable law. And I too very much appreciate the fact that counsel have come for oral argument today on very expedited basis. And a nice job of submitting written materials to the court which are helpful, and also participating in oral argument. I'm going to digress for a moment and remind people who see this opinion and wonder what's going on. Fundamental to the work of this court is a recognition that it is only one of three branches, three equal branches of our government. The role assigned to the court is not to create policy, and it's not to judge the wisdom of any particular policy promoted by the other two branches. That is the work of the legislative and executive branches, and the citizens who ultimately, by exercising their rights to vote, exercise democratic control over those branches. The work of the judiciary is limited to ensuring that the actions taken by those two branches comport with our laws and, most importantly, our Constitution. There is a very narrow question before the court today that asked to be considered, and that is whether it is appropriate to enter a TRO against certain actions taken by the executive that are enumerated in this specific lawsuit. Although that question is narrow, the court is mindful of the considerable impact that its order may have on the parties before it, the executive branch of our government, and the country's citizens and residents. I will not repeat the procedural background of this case. It will be in the written order. But instead, note that with the motion was filed and that the federal defendants oppose the state's motion. Any question regarding lawsuits in federal court starts with the issue of does the court have jurisdiction over the federal defendants and the subject matter of the lawsuit. In terms of notice to the federal defendants, that was certainly accomplished, and indeed the federal defendants have appeared and argued before the court and defended their position in this action. And since this is a attack based on the Constitution and federal law, I find that I do have subject matter jurisdiction. The standard for issuing a restraining order in this circuit is the same as for issuing a preliminary injunction. A temporary restraining order is, as the government has noted, an extraordinary remedy that may only be rewarded upon a clear showing that the plaintiff is entitled to such relief. A citation to the Winter case, which is well known to the lawyers. The legal standard for preliminary injunctive relief, and hence for a temporary restraining order, is that the plaintiff must be likely to succeed on the merits, that it will suffer irreparable harm in the absence of preliminary relief, that the balance of equities tips in their favor, and finally that the injunction is in the public interest. The Ninth Circuit has an alternative test which it's used from time to time and is well known to the parties, and it will be in the written order. It is an interesting question in regards to the standing of the states to bring this action. I'm sure the one item that all counsel would agree on is that the standing law is a little murky. I find, however, that the state does have standing in regards to this matter, and therefore they are properly here. And I probed with both counsel my reasons for finding that, which have to do with direct, immediate harm going to the states as institutions, in addition to harm to their citizens, which they are not able to represent as directly. Therefore, turning to the merits, the court finds that for purposes of the entry of the temporary restraining order, that the state has met its burden of demonstrating that it faces immediate and irreparable injury as a result of the signing and implementation of the executive order. I find that the state has satisfied the test that it is likely to succeed on the merits of the claim, which would entitle them to relief. I find that the balance of equities favor the states. And lastly, I find that a temporary restraining order is in the public interest. If I were to apply the Ninth Circuit's alternative test, I would find that the states have established a serious question going to the merits, and that the balance of equities tips sharply in their favor. As such, I find that the court should and will grant the temporary restraining order. The scope of that order is as follows. Federal defendants and all their respective officers, agents, servants, employees, attorneys, and persons acting in concert or participation with them are hereby enjoined and restrained from A, enforcing Section 3C of the executive order, B, enjoined and restrained from enforcing Section 5A of the executive order, enjoined and restrained from enforcing Section 5B of the executive order, or proceeding with any action that prioritizes the refugee claims of certain religious minorities, enjoined and restrained from enforcing Section 5C of the executive order, and lastly, enjoined and restrained from enforcing Section 5E of the executive order to the extent Section 5E purports to prioritize refugee claims of certain religious minorities. This TRO is granted on a nationwide basis and prohibits enforcement of Sections 3C, 5A, 5B, 5C, and 5E of the executive order at all United States borders and ports of entry, pending further orders from this court. I considered the question of the government's request that the order should be limited to Minnesota and Washington, but I find that such partial implementation of the executive order would undermine the constitutional imperative of a uniform rule of naturalization and Congress's instruction that immigration laws of the United States should be vigorously and uniform. That's language from Texas versus the United States, 809 Fed 3rd 134 155, 5th Circuit 2015. I find that no security bond is required under the Federal Rules of Civil Procedure 56C, and I direct that the parties confer and get back to the court promptly. Today wouldn't be too late, but by next week, regarding a date for the preliminary injunction hearing, the time for the motion for the preliminary injunction, the time for the federal defendants to file their opposition, and for the states to file their reply. Once we know that, we'll promptly schedule a hearing on the motion for preliminary injunction after we are in receipt of the parties' briefing. The court concludes that the circumstances that brought it here today are such that we must intervene to fulfill the judiciary's constitutional role in our tripart government. Therefore, the court concludes that entry of the above-described TRO is necessary, and the state's motion is hereby granted. Counsel, anything further at this time? Mr. Brazell? Ms. Bennett?
One more thing, Your Honor. As a procedural matter, the government would move, Your Honor, to stay the TRO, the same purposes that we oppose the TRO, pending a decision by the SG of whether to appeal, to file an appeal.
I'm sorry, pending a decision by the...
By the Acting Solicitor General. I'm sorry, Your Honor. We use lots of acronyms.
Yes.
By the Acting Solicitor General.
I understand the motion, and I'm going to deny it.
Thank you, Your Honor.
I will do everything I can to get you prompt appellate review, which I think is the appropriate case to take.
Thank you, Your Honor.
We will be in recess. Thank you, counsel.